Welcome to Brown Act 2026 updates. I am Belinda McCauley, CEO of BHBA, and I am delighted to be here today to introduce our speaker, Kelly Doyle. Kelly is an associate at Cole Huber LLP in Roseville, California, where she focuses her practice on municipal law and civil litigation. She earned her JD from the University of the Pacific McGeorge School of Law and began her legal career serving vulnerable youth as an attorney and intern with the Children's Law Center of California before going on to develop her expertise in municipal and environmental law at another law firm. And now let's get started.
Great. Thank you so much, Belinda. I really appreciate the introduction. Thank you so much to everyone who is here today. I really appreciate you taking time out of what I know are busy schedules, as we're all attorneys, and we all have lots to do. So I appreciate you joining me to talk about the Brown Act. So as Belinda already mentioned, I'm a municipal law attorney. I have most of my practice throughout the years has been in the municipal law arena. I represent public agencies in civil litigation matters, and I also practice in municipal law where I advise public agency clients on compliance with the Brown Act. And so that's why we're here today. We're here to talk about the Brown Act. More specifically, we are here to talk about Brown Act updates that came in the form of a Senate bill, Senate Bill 707, and I'll get to that in a minute. But these updates are they're big updates in the realm of the Brown Act, and it's important if you represent municipal agencies or if you ever deal with local government that you're aware of these new updates so you can best advise your clients on how to work with these agencies to make sure that they're engaging in transparent government, because that is the focus of the Brown Act: transparency and access. So over the last 6 years, the Brown Act really has underwent major changes as a result of the COVID-19 pandemic. Because of social distancing, local agencies had to pivot to figure out how to conduct meetings remotely while also remaining in compliance with the Brown Act, which is tricky. So many agencies moved into a remote hybrid model. Essentially, they would allow public access through platforms like Zoom, or they would have two-way teleconferencing phone devices that they could use to engage with the public. While it was assumed at the time that these remote meetings would be temporary, local governments found that actually more people were participating in the government process because of this increased access. So bearing that in mind, SB 707 and these Brown Act updates that I'm going to discuss today aim to continue that vein of more access for the public in terms of being involved in government meetings. So I did want to mention, because your association's membership spans a variety of practice areas, before I get into the specific Brown Act updates, I thought it might be helpful to start the presentation with a quick primer on the Brown Act, since I'm not sure if everyone will be familiar with its provisions. So could we go to the first slide, please? Thank you so much. So the Brown Act, or the Ralph M. Brown Act, is the statutory scheme that governs California's open meeting laws for local government agencies. It is the operative principle of the Brown Act is that the public retains sovereignty over its agencies. So it follows necessarily that public business must be conducted openly so that the public can remain informed. Therefore, to ensure that public sovereignty over local government remains intact, the legislature created the Brown Act to promote transparency and public trust in the government process. So how the Brown Act did that is it codified three important concepts. One, the people's right to attend meetings. Two, the people's right to participate meaningfully in government deliberations. And three, the ability to hold their local governments accountable if these decisions that were being made were not, were not being conducted out in the open. So I've used that phrase a lot, open, conducting business openly. Now, what does that mean for a local government agency to conduct its business openly? Um, so I would start first in understanding what it means to have an open meeting. The first place I would start to understand how the Brown Act operates practically is by looking at precisely who the act applies to. So the statute says that all meetings of a legislative body of a local agency shall be open and public. So you'll note there's a distinction there between the local agency itself and the legislative body of that agency. And that's an important distinction. And let me provide an example of how this distinction works in practice. So I live in Folsom, California, which is part of Sacramento County. Under the Brown Act, the County of Sacramento would be the local agency, but its Board of Supervisors would be the legislative body that the provisions of the Brown Act apply to. So when the Board of Supervisors holds meetings on county business, barring some exceptions, those meetings are subject to the provisions of the Brown Act. Now, the county also has a wide array of departments that operate to conduct government business. So you're probably wondering, are all of these separate departments necessarily subject to the Brown Act as well? And the answer to that is no. Counties like Sacramento can create commissions or committees by charter or resolution that would be subject to the provisions of the Brown Act. But if we're talking about, a county government, you have departments such as water resources, you have child protective services. Those separate departments are not necessarily, they're not all beholden to the Brown Act. It's really legislative bodies of either city councils, county board of supervisors, special districts, or commissions or committees created by a city or a county to provide services and for their local government. So it can be a little bit tricky to determine, especially when we're talking about things like subcommittees and ad hoc committees, to determine whether or not those groups are subject to the provisions of the Brown Act. And I won't get too into the weeds on that, but essentially all you should know is that there's a distinction between an ad hoc committee and a standing committee in the Brown Act. A standing committee is a committee, that is formed by a legislative body to tackle a specific subject. And a standing committee has enduring subject matter jurisdiction, meaning it is a committee that will exist in perpetuity. Whereas an ad hoc committee, on the other hand, and that the standing committee is subject to the provisions of the Brown Act. Whereas on the other hand, an ad hoc committee, they're formed for discrete purposes to address time-limited tasks. Those are not subject to the Brown Act provisions. So all that to say, even at the first hurdle, the Brown Act can be tricky. Understanding exactly what constitutes a legislative body can be complex, particularly if you're dealing with larger local agencies like cities and counties, as they often create subcommittees and ad hoc committees that may or may not be subject to the provisions of the Brown Act. As a public agency lawyer, I think it's important to consult with your client before any committee is formed to determine whether Brown Act compliance will be necessary, because the last thing you want is to have a lawsuit filed against you because a subcommittee was not properly, we're not properly noticing and agendizing meetings. Which brings me to the next step in the Brown Act. So what constitutes a meeting for the Brown Act? As I mentioned in the beginning of this presentation, the Brown Act is California's open meeting laws. So what is a meeting? So the Brown Act provides that a meeting means any congregation of a majority of the members of a legislative body at the same time and location, including teleconference, to hear, discuss, deliberate, or take action on any item that is within the subject matter jurisdiction of the legislative body. Let me break that down and simplify it. Basically, a meeting under the Brown Act, you need to have a meeting, you need a majority of the members that are discussing agency business at the same time or through serial communications. So you can see that the statutory definition of a meeting is intentionally expansive. Um, if you represent local government agencies, it's really important to understand the scope of what constitutes a meeting. This is because you can have situations where members will be talking about agency business amongst themselves outside of a regularly scheduled meeting, and those conversations could potentially be a violation of the Brown Act. And importantly, there does not need to be a formal action or a vote in these discussions for the Brown Act to potentially apply. It's one of the biggest misconceptions that lawyers have. Your client will say, "Well, we didn't decide anything, so there's no problem." But deliberation alone can trigger the Brown Act. And, the modern challenge now is that meetings are no longer just confined to rooms. We have emails, text, Zoom chat, Slack channels, social media. This can all create Brown Act exposure. And while I will say the subject of serial meetings and what constitutes a serial meeting is a pretty complex subject that I don't have time to go into today because this is a 30-minute presentation. But just to wrap this up, just remember that a meeting is anytime you have a majority of the members discussing agency business at the same time or through serial communications. So it doesn't have to be in a room. It can be over a text message. It can be over email. It's really, really important when you represent public agency clients to make sure they really understand these provisions. So let's move on to the next portion of the Brown Act, which is the agenda requirements. Oh, could you go back a slide, please? Thank you, thank you. So agenda compliance is deceptively technical, but it's really important. The agenda is essentially your notice requirement, right? Lawyers, we know a lot about notice requirements. For the Brown Act, the agenda, before every meeting, a government body will need to create an agenda that will note all of the items that are going to be discussed in that meeting. For regular meetings, agendas have to be posted 72 hours in advance. Most public agencies post them on their website, but they also have to post them in a conspicuous public place. The most litigated issue regarding agenda requirements is what is known as the adequacy of the description. So an agenda item description has to provide enough information for a reasonable member of the public to understand what the agency intends to discuss or act upon. So you can't use vague descriptions like personnel matter or legal update or policy discussion. There has to be more. Or else, again, you open yourself up to potential litigation. It's something. A simple act of just rephrasing an agenda item could do that. You don't want to put your client through that. So I would recommend if you represent municipal governments, review significant agenda items before posting them. It's always good to have an extra set of eyes, particularly attorney eyes on agendas. Okay, so let's see. Let's go to the next slide, please. Okay, so now we're getting into the meat of this topic, which is I described a bit at the beginning of this presentation, the 2026 updates to the Brown Act. These updates were made via a Senate bill called Senate Bill 707, which was signed into law in October of 2025, and it became effective primarily on January 1st, 2026. Many municipal law practitioners see this as one of the largest modernization efforts of the Brown Act in decades. There are a lot of changes. So, and as I already discussed, these changes came about because of COVID-19, essentially. it really changed the way public agencies operate in California in terms of open meetings. It's really interesting to look at the Brown Act in a pre-pandemic lens and a post-pandemic lens. And honestly, it almost seems archaic the way we used to operate when it came to having, our open meeting requirements. But it's the reason why it's so important for council for local government to keep abreast of these changes. It's because there are some pretty onerous requirements on a large swath of local government agencies that were brought about by this bill. And, I want to really make sure that we cover those items, so you guys, leave here with a good knowledge of what's coming down the pipeline this year. So, the SB 707 substantially reorganizes and modernizes the Brown Act by making certain pandemic era teleconferencing rules permanent. It also expands remote and hybrid public access requirements. It also adds language accessibility obligations, and it also increases website posting and public notice requirements. And finally, it also creates enhanced compliance rules for certain larger bodies, known as eligible legislative bodies. Next slide, please. Okay, so I already touched on this a little bit, but what we're really going to be focusing on today, are these three topics. What is an eligible legislative body? Um, what are the new teleconferencing updates brought about by SB 707? And what are the increased access provisions that were brought about by SB 707? Next slide, please. Okay, we are going to talk about the eligible legislative body. So SB 707 created a new category called an eligible legislative body. It generally applies to larger cities, counties, and certain high revenue special districts. Next slide, please. So this slide gives you a little bit more information as to how an eligible legislative body is determined. So an eligible legislative body falls into three different categories. First, we have city councils and county boards of supervisors with populations of 30,000 or more. We also have city councils in counties with a population of 600,000 or more. And then special districts that have an internet website and either of the following, 1,000 full-time employees, or they are located in a county with a population of 600,000 or more. So just to provide another example using Sacramento as my barometer here. So obviously the city of Sacramento has a population of over 30,000. The county of Sacramento also has a population of over 30,000. So they would be considered an eligible legislative body, and therefore different requirements are going to be or apply to them as opposed to these smaller legislative bodies. Let's say, and then you have a city council in a county with a population of 600,000 or more. Sacramento County has a population of 600,000 or more, easy. I'm not off the top of my head, I can't think of any cities incorporated in the county that have a population under 30,000 that this would apply to. But if they did, even if they didn't have, if their population was less than 30,000, because they're in Sacramento County, they are an eligible legislative body. Okay, next slide, please. So, the next thing I wanted to talk about is teleconferencing. So the pandemic transformed Brown Act practice. Emergency legislation temporarily relaxed traditional teleconferencing rules and normalized fully remote meetings. So for example, before the pandemic, if a member of a legislative body wanted to teleconference, they were required not only to post the location of where they would be teleconferencing from, they would also be required to make sure that that location where they're teleconferencing was accessible to the public. Now, I'm sure most of you are thinking the same thing. Most people, when they need to teleconference, they're doing it from home. So in practice, it would be a little strange to have your home listed as a teleconferencing location that is accessible to the public. So it was just a little bit of an archaic way to operate. But the pandemic really changed things in terms of teleconferencing under the Brown Act. Um, so due to social distancing measures, legislative bodies were no longer required to provide a physical location for the public to speak, but they were required to have video or telephonic call-in options. And members of the legislative body didn't have to post their location on the agenda and open that location to the public. So, next slide, please. SB 707, it aims to continue this flexibility for members to participate remotely in specific circumstances. And I want to note that these teleconferencing provisions, they apply to all legislative bodies, not just eligible legislative bodies. So the specific circumstances in where a member can teleconference remotely and not have to follow the strict pre-pandemic teleconferencing rules. There are three that I'll fill you in on. One is if there's a state of emergency. Before SB 707, only state emergencies allowed members to participate remotely. But the new updates provide that local emergencies also trigger remote participation flexibility. This changes a boon for small rural communities that are often hit hard by natural disasters. And they often have limited resources to engage in reconstruction efforts. So they really benefit from being able to teleconference in these scenarios. The other way a board member could utilize teleconferencing without having to follow the pre-pandemic rules is if they have an eligible disability that requires a reasonable accommodation that includes remote participation in meetings. SB 707 allows for this. The only requirement on the member is that they need to disclose any present adults and their relationship to the member, and they have to participate via audio and camera. The last category that allows a member to participate remotely without having to use the pre-pandemic teleconferencing rules is for just cause. So members of a legislative body can participate remotely without being required to comply with the traditional Brown Act teleconferencing rules if they have what is known as just cause. Under the Act, just cause can include childcare. It can include caring for an elderly or sick parent, grandchild, sibling, or spouse. It can also be found if the member has a contagious illness. There's a need related to a physical or mental health condition that they're dealing with, or they have to deal with a family emergency. So the one thing I will note about the just cause exception is that there are limitations to how many times a year a member can use the just cause exception. So that should be noted if you have members in your legislative bodies that you represent that are dealing with perhaps like a family crisis or an illness. It'll be good to chat with them to make sure they know how many days they can teleconference before they're in violation of the rules. So just wanted to point that out. Okay, so SB 707 has these rules are now codified and for the next, I believe these rules will sunset in 2030, these teleconferencing rules. But it's very likely that these rules will become permanent because as we mentioned, the world has become more technologically advanced, and being able to provide flexibility when it comes to remote participation in public meetings is the future. And I think these updates are recognizing that. Okay, next slide, please. So now that we have touched on teleconferencing flexibility, the final topic I'd like to address is the new accessibility requirements mandated by SB 707. So as I've discussed throughout this program, the touchstone of SB 707 is accessibility. All roads lead to greater accessibility for members of the public. The legislature recognized the need to modernize the Brown Act for a technologically and culturally diverse society. So these accessibility provisions ensure that Californians, no matter where you're situated, can have a stake in the government process. Next slide, please. So first, we're going to talk about the new hybrid meeting requirements. And I will note these hybrid meeting requirements only apply to eligible legislative bodies. So those big cities, those big counties, those big special districts. This will apply only to them. So before SB 707, providing audio or telephonic access to a government meeting was optional. It wasn't required. Now, all eligible legislative bodies will be required to provide hybrid meetings moving forward. The law also provides that the legislative bodies must include an opportunity for members of the public to attend public meetings via a two-way telephonic service or two-way audio-visual platform by publicly posting and providing a call-in option on the agenda. So, and finally, all open and public meetings utilizing these remote call-in options must include an opportunity for the public to comment via these remote teleconferencing options. And the final thing that's important to note, and this needs to be done by July 21st, 2026. All eligible legislative bodies must approve at a properly noticed public meeting in open session a policy regarding disruption of telephonic or internet service occurring during public meetings. Okay, next slide, please. So, in continuing to talk about expanding access to open public meetings, SB 707 not only expands access technologically, but also expands language access for members of the community who might not speak English. Again, these language access provisions only apply to eligible legislative bodies. So your big cities, your big counties, your big special districts. So what does expanding language access mean under SB 707? Well, it essentially provides for additional expansion of access to meetings by requiring eligible legislative bodies to provide translated agendas in all applicable language for members of the public. So the agenda for each meeting has to be translated into all applicable languages, and each translation has to include instructions in the applicable language describing how to join by telephone or internet-based service option. So an applicable language, that means any language spoken jointly by 20% or more of the applicable population, provided that 20% or more of that same population speaks English less than very well. And this is determined by data from the most recent American Community Survey. So it really will be important if you represent public agencies to have, to look at the demographics of your client's agency to make sure that they are covering all applicable languages. So additionally, according to the bill, applicable populations will be determined depending upon the type of the eligible legislative body. For example, the applicable population for an eligible city council or county board of supervisors would be the population of the city or county. However, for a special district, the applicable population can either be the population of the county with the greatest population within the boundaries of the district, or the population of the service area of the special district. Next slide, please. Okay, this is the last slide in the presentation. So the last piece of the increased access puzzle is related to encouraging underrepresented communities' participation in open and public meetings. So beyond providing access, remote by providing technological access, language access, eligible legislative bodies are now going to have to make an effort to go out of their way to make sure that underrepresented populations have a chance to attend and be a part of the government process. So, what the statute says is eligible legislative bodies will be required to make a good faith effort to encourage residents, including those in underrepresented communities, to participate in public meetings. They do this by creating an electronic system for accepting and fulfilling requests for meeting agendas. Additionally, they also are going to be required to create and maintain a website specifically dedicated to public meetings that includes or provides links to general explanation of the public meeting process and an explanation of the procedures for a member of the public to provide in-person or remote comments. And also, eligible legislative bodies will have to make reasonable efforts as determined by the legislative body to invite groups that are do not traditionally participate in public meetings to attend the same. So efforts can include reaching out to media organizations that provide news coverage in the jurisdiction of the legislative body, including non-English speaking media organizations or neighborhood and community group organizations. But I will note that SB 707 gives eligible legislative bodies broad discretion to determine what constitutes a reasonable effort. I know when I read that portion of the bill, my litigator brain went off as I was thinking to myself, what is going to be a reasonable effort? And are there going to be lawsuits wherein people are going to be suing legislative bodies for not engaging in a reasonable effort to reach out to underrepresented communities? That's something that went off in my litigator brain. And so I think it's important in terms of this piece of the updates to make sure that you develop a plan with your agency to make sure you check off all of these things regarding encouraging underrepresented community participation in the Brown Act.